Oh, hello, and welcome to this special coronavirus edition of Professional Responsibility. Today, we'll be talking about the application of the attorney-client privilege.
As you know, the duty of confidentiality is a fiduciary duty that requires attorneys to protect private information about their clients. The attorney-client privilege also protects confidential information about clients, but is far stronger than the duty of confidentiality. While the duty of confidentiality imposes a duty on attorneys, it doesn't impose a duty on courts. Attorneys can't disclose confidential information about their clients unless the court requires them to disclose. And courts often require parties to disclose confidential information in the discovery process. Indeed, the disclosure of relevant confidential information is one of the reasons courts created discovery in the first place. By contrast, the attorney-client privilege is an evidentiary privilege that protects certain communications between attorneys and their clients from disclosure. Of course, information protected by the attorney-client privilege is also protected by the duty of confidentiality, so attorneys have a fiduciary duty not to disclose it. But unlike merely confidential information, it is also protected from compelled disclosure. In other words, if information is protected by the attorney-client privilege, it isn't subject to discovery, and courts can't force attorneys to disclose it unless an exception applies. Because the attorney-client privilege provides such strong protection, courts impose strict limits on its scope. Most importantly, information is protected by the privilege if and only if it is a private communication between the attorney and the client. If the information is communicated to a third party, the privilege may be destroyed. There are many different kinds of evidentiary privileges, like the spousal privilege, the doctor-patient privilege, and the priest-penitent privilege. In some ways, the attorney-client privilege resembles those privileges because it protects certain communications from compelled disclosure. But it also has features that are unique to the context of legal representation. Like the duty of confidentiality, the attorney-client privilege belongs to the client, not the attorney. While attorneys must protect confidential and privileged information from disclosure, their clients can waive confidentiality and privilege and disclose at will, or even by accident. Accordingly, attorneys should inform their clients when information is confidential or privileged and discourage them from disclosing that information. In order to claim the attorney-client privilege, you will need a communication made between privileged persons in confidence for the purpose of obtaining or providing legal assistance for the client. While the specific definitions of these requirements vary from state to state, there is a lot of commonality. A communication is generally defined quite broadly as any expression used to convey information between an attorney and a client. Of course, the information communicated may not necessarily be protected by the privilege if it is otherwise subject to disclosure. But the fact the information was communicated is protected, as well as any non-discoverable information and any legal advice provided in response to the communication. A communication is privileged if and only if it is between privileged persons. In other words, a communication between an attorney and a client is privileged, but any other communication is not. In other words, many communications are confidential, but not privileged because they are private communications that do not include an attorney providing representation. In addition, a communication between an attorney and a client is privileged if and only if it is made in confidence. Accordingly, if anyone other than the attorney and the client receives the communication, it is no longer privileged. So, if a third party is included in a conversation between an attorney and a client, the communication is not privileged. And if the client provides an otherwise privileged communication to a third party, it may destroy the privilege. Finally, a communication is privileged only if it is for the purpose of obtaining or providing legal advice. Attorneys provide many different kinds of advice to their clients. Not all of the advice provided by an attorney is legal advice. For example, attorneys often provide business advice and may also provide personal advice. The mere fact that an attorney providing legal representation to a client is part of a communication does not necessarily make the communication privileged. The attorney-client privilege attaches only if, and to the extent that, the communication in question was actually for the purpose of obtaining or providing legal advice. Other kinds of advice may be confidential, but are not privileged.